All right, we're going to go ahead and call this committee to order and start our children and family for the week. And I know everyone's surprised to see me talking right now, but I've got, I'm starting the meeting for Chair Lady Littleton. She's in Criminal Justice Subcommittee. She's got 3 bills to present. Once she gets back, she'll take over. So with that, if we go ahead and call the roll.
Representatives Bricken, Farmer, Gant,
Here.
Garrett, Harris, Jernigan, Powell, Stevens, Littleton. Mr. Chairman, you have a quorum.
Thanks so much. Members, any personal orders or announcements before we start today? All right, seeing none. And I do have one announcement before we get started. It looks like we have quite a bit of potential testimony today for the bills. So each person to testify will be limited to 3 minutes. We've got a three-minute limit on testimony, unlimited time for questions. That's across the board. That's how we do it in civil full, civil sub, and other committees that are with this one. So with that said, those are the rules regarding testimony. And that brings us to the calendar. And what we're going to do is, without objection, item 1, House Bill 1676. We're going to roll that at the Hill because till Chair Littleton gets here, that's her bill. So without objection, item 1, House Bill 1676 to the Hill. Brings us to item 2, House Bill 2183 by Chairman White. And I don't see any committees there, sir. You've got a motion and a second, and you're properly recognized.
Thank you, Chairman and committee. This is a bill that I carried with Senator Hale a few years back. It's called Safe Baby Courts. The purpose of it, what we're basically doing is keeping this from sunsetting going forward. I think it was due to sunset January 1, 2025. But let me give you just a little background in case you have forgotten about this. The purpose of the Safe Baby Court program is to reduce the incidence of child abuse, neglect, and endangerment, and minimize the effects of childhood trauma on our state's most vulnerable population. Since the time we first passed this, we have continually expanded the program, and there are now 13 fully operational safe baby courts across our state, and 8 more which will come online hopefully in the next year. The bill simply allows the program to remain in place without a sunset, so we can continue providing resources for increased stability in Tennessee homes. This is basically for children 0 to 3 that are being brought before the court. The point of it is try to get the child into a stable environment and home without languishing in the adoption process. And as of February, just a couple of facts, as of this past month in February, there have been 554 cases serving 1,006 kids. Of those 1,006 children, only 2 of those children have re-entered custody within 6 months of the case closures. So the Safe Baby Courts children reach permanency about 94 days sooner than the national average. So the program is working. That was the idea when we set it up a number of years ago, and we just want to keep it going. There's no additional funding request that was put in the original bill. This was just keep it from sunsetting because it is an effective program.
Thank you, Chairman White. It's a great explanation. Members, any questions or comments for Chairman White? Seeing none, are we ready to vote? Looks like we are. Looks like we're ready to vote. Send House Bill 2183 to civil full. All those in favor say aye. Aye. Opposed say no. Ayes have it. Bill moves on. Thanks, sir. Brings to item 3, House Bill 2598 by Representative Johnson.
Motion. Second.
And you got a motion and a second. Ma'am, and I don't see any amendments traveling with this, so you're properly recognized.
There's been some monies put into it that have helped to a degree. We are hiring more folks, but until we remedy the situation of a caseload cap in DCS, we will be back in the same boat because the previous language asked for an average of. And so that's how we got so backlogged with people having 60 to 90 on their caseload. And if we put a cap on this language so that we're not allowed to go over that, we can ensure that we don't get back in the situation that we were in. And I know that still today across the state, we are putting kids, we're not putting them in offices too much, but we're still putting them in facilities that are not homes where they have to be monitored 24/7 by DCS workers. DCS workers who are not trained to work with specific kinds of kids, like kids with disability, kids with autism, or deaf children. Imagine being ripped from your home and having to go to a place where no one understands how to communicate with you. And they just sit there in a chair and watch you for 24 hours, and that person changes about every 5 to 6 hours. I can't imagine what that would feel like, not having someone that you could communicate with. But it allows a step down process where you go to 20 and then go to 14. And so I just think it's critical until we put a cap on the number of cases that someone can have, we're going to be back in the situation of having people with 50 to 60 on their caseloads. And as they did in Davidson County, some had 90 on their caseload.
Very good. And thank you for that explanation. Members who have any questions for Representative Johnson? Representative Harris, you recognize.
Thank you, Chairman. So the sponsor, do you know what is the average right now? What are they averaging around?
They can't give us an average right now. What they'll say is, well, there are some places where the caseload is 14, but people are still contacting me across the state. And I know there's still people with over 50 on their caseload. The department feels like it'll be tough in the timelines allotted here for them to get there. But I think that we have to do absolutely everything we can to try, because in the meantime, kids are getting more and more trauma as they don't have a stable place to be, and they don't have a caseworker that's able to stay with them through this process.
Thank you.
Members, any additional questions or comments for Representative Johnson? Chair Lady Littleton.
Thank you, Mr. Chairman. I totally agree that we need more caseworkers and less cases, but we're still a little bit below on our hiring. Our DCS is on the hiring, so this will put such a burden on them. I think they're doing the best they can do. We've upped the pay, and we're down to, I think, a little under 250 of the employees that we were behind. So I don't see how we could do this right now.
Well, this gives them a year.
Representative Johnson, you recognize.
Sorry about that. Yes, this gives them a year to get that done and creates a step down process. I think that we have to express how important this is because of the extra trauma that kids are suffering as they're waiting for things to happen. And so I know that recently the comptroller asked an economist, what is the biggest problem in Tennessee? And it's a worker shortage. And we know that that worker shortage comes from a lack of childcare, lack of transportation, affordable housing, and healthcare. But with the things that we're doing, people are coming into the job. And I think if we continue to recruit and hire, we can do this. We can get there. Maybe we can talk about adding another 6 months, but I believe that with the hires we've already had, we've had a year to work on this. We should be able to get there in another year. And this gives us a year to get there.
Chair Lady Littleton, any follow-up?
Thank you, Mr. Chairman. I just think we need to wait for another year to put this pressure on DCS. So I don't think we need to do it now because they're doing the best they can do, and they're still below there's still 260 open jobs positions.
Members?
I have a reply.
Sure, go ahead. You recognize. Representative Johnson.
Yeah, but we put this off another year and there's no standard that we're trying to move to. I don't think we'll ever get there.
I appreciate it. I'll just say this. I think you had made the comment that we're moving in the right direction and that we are hiring and getting where we need to get to with regards to the department. A year is a fairly short amount of time, you know, when you're trying to vet and hire the right people for these jobs, because the last thing we want to do is put a timetable, a 1-year timetable on a entity and tell them, hey, look, you're going to have to hire all these people within this period of time. So in turn, what they're going to do, they're going to do exactly what we tell them to do. They're going to hire all these people. And what I'm afraid is going to happen, they're going to make bad hires because we need the most qualified, dedicated folks taking care of our children here in Tennessee. So I just think that it's okay to have some patience with the department, considering the progress that they've made moving forward. And they, like you said, you know, they've made progress. They've increased pay. They've increased benefits. They've made all the right moves to try to move in the direction that you're wanting to go. And philosophically and from a policy standpoint, I agree with you. But I think, as Chair Lady Littleton said, let's give them some time to continue moving in the direction that they're going. But with that said, I'll give you an opportunity to respond, and then Representative Jernigan has a question for you.
Okay, they're moving in the right direction, but there's nothing to make sure that they continue to move in that direction. And there are still serious problems. I'm still getting calls every week from folks that are overcrowded and don't have place to put kids and are sitting with kids in addition to doing their caseloads. So I think that we have to make sure this happens. We don't want to this is going to be 2 years. It will be 2 years by the time this period is over. And how long are kids going to have to wait in these traumatic situations before we actually do something to ensure it won't happen again?
Thank you. Representative Jernigan, you're recognized.
Thank you. I agree with the 20 case. I have a question. So if say a year goes by, we do the year and it goes by and they're down to maybe 30,
Mm-hmm.
are they then open to a lawsuit because they haven't met the 20? Or I would like to see where kind of tiered that you do this percentage in a year, this percentage, then you hit the 20 if they can't hit it. Because I am worried about us not having enough bodies, but I don't want them to be sued for something like that either.
Representative Johnson, you're recognized.
According to the department, my final number is actually 14. The step down is to 20. And the department seems to think like 20 is not a problem. They wanted me to put in the language of an average, but we had an average of 20 before, and that was the problem. And so I don't want to put an average in this bill because that can be manipulated and get us in the situation we were in before. We need a cap. Now I'm willing to think about maybe an additional 6 months, but I just talked to the department, and according to them, they seem like they're pretty close to that 20. So 6 more months to get to 20, why not? And the social work standard is typically 12, but it's 12 to 15, depending on what you're reading. So I tried to move it up a little bit closer to where the department was to 14, but still yet that is the social work standard to have good care.
Any follow-up? No. Members, any additional comments or questions for Representative Johnson? Seeing none, we're ready to vote. Any objection? Seeing none. Looks like you're voting whether or not to send House Bill 2598 to civil full. All in favor, say aye. Aye. All opposed, say no. No. Noes have it. Bill fails.
Thank you, Committee.
And with that, Chair Lady, it's your committee.
Thank you, Chairman Farmer. Number 4, House Bill 1804 by Representative Butler has been taken off notice. So we're on item 5, House Bill 2067 by Representative Butler.
Motion. Second.
Properly motion and second, you're recognized.
Thank you, Chair Lady and committee. Of course, we had a great discussion last week about this legislation, and I appreciate the discussion. And we're before you again today to pass legislation that would create a grant program to allow a county to apply for monies to install a safe haven baby box. And I'm glad to answer any questions. I can go through the law and some of those other issues, and be glad to answer any questions. With that, I'll renew my motion and stand for questions.
Representative Gant, you're recognized.
Thank you, Madam Chair. Since our last week meeting, I've had a chance to talk with the sponsor and do a little research on my own with some people across the state. And I think this is a very good piece of legislation that I can now agree to now that I've had my questions answered. And so I applaud the legislation. I think the intent is a very good one. And anytime we have something like this that comes before us, we should support. So thank you, Madam Chair.
Any other questions?
Do we need to, and if I missed this, I apologize. Have we adopted the amendment yet? It's on.
Okay, I apologize. Thank you.
Are there any other questions? Representative Harris, you're recognized.
Thank you, Chairwoman. So we didn't make any changes from the conversation from last week. There's no amendment.
You're recognized.
There is an amendment on the bill that we added last week, and my understanding that stands as it is.
So no amendment around trying to make sure that we work with the other organizations and provide resources to that in that direction
Well,
either.
I'm going to kind of answer that anyway. We've been working with them from the beginning,
Mhm.
so, but you're recognized, Representative
Thank you,
Butler.
Madam Chairman. As she said, they're already receiving funds through the General Assembly to do that education and so forth. So this legislation's, pretty much stands on its own merit to create this grant program, and it'll be up to the Finance Committee to determine whether they award the dollar amount that they award if this passes.
I do too. I want to say that I don't think that we could put any kind of value on a baby's life. So I was for the bill last year and I'm still for the bill. So any other questions? Are we ready to vote? All those in favor of House Bill 2067 moving out to civil full, say aye. Aye. Those opposed, no. The ayes have it. Your bill moves out to civil full.
Thank you, committee.
Next up is number 6, House Bill 2404 by Representative Slater. He has rolled that 1 week. And next is number 7, House Bill 1913 by Representative Bolso. It's been rolled to March 5th calendar. Oh, I actually done. And number 8, House Bill 2483 by Representative Harris. Representative Harris.
Second.
You're recognized.
Thank you, Chairwoman. And so on this bill, I'm pulling this bill off of notice.
Oh, okay.
Oh.
So House Bill 2483 is off notice. So next is number 9 on our calendar, House Bill 2503 by Representative Harris.
Motion second.
You're properly motion and second. You're recognized.
Thank you, Chairwoman, and to the committee. House Bill 2503, as introduced, requires that the court to include in any parenting plan involving sharing custody of a child, the establishment of at least one designated location for the exchange of the child, provides that unless otherwise agreed by both parents in writing, the court may require the parents to exchange the child at a neutral, safe exchange location, and requires that each sheriff, so it would require that a sheriff's location jurisdiction, within that jurisdiction, at least one of the locations has a safe, neutral spot for people to have exchange of their child during custodies. Oftentimes, even in public places, custody exchanges and visitations can turn heated. And the goal of establishing a safe exchange zone is to be able to monitor the situation and keep everyone, including the child, safe. We have gotten some really good support from our judges and community partners on this. One judge mentioned that we have seen some cases where domestic violence issues and cases where at the exchange, the children are a part of the drama, and it's unfortunate. The Resource Center on Domestic Violence reports custody hearings and visitation exchanges often become opportunities for violence. Separation also can put a strain on the situation and can lead to an abuser using more severe violent tactics like stalking or using a child as a target or tool for punishment. So what a safe exchange does is gives the child the opportunity to go from one parent to the next parent with a buffer in between, so that they don't have to see the difficulties that their parents are having. And so there's already one sheriff's department already doing this within our state already. They have a purple sign outside at their sheriff department that lets them know that that's a safe area for them to exchange the child during custody battles if they need to. And so that's the language for the bill, and I would love the support from our committee.
Thank you. Are there any questions for Representative? Representative Garrett, you're recognized.
Thank you, Madam Chairman. Just a couple of questions. Thank you for bringing the bill. Of course, we want parents to exchange things when they can't get along,
Yep.
knowing that it affects the lives of their children. Couple of quick questions, though. Does the language mandate that the judge has to establish a place, and then that place is the sheriff's? And let me kind of preface that with why I'm asking is that lots of times a natural exchange is when you drop them off at school. One parent drops them off on Monday, and if Monday afternoon is the other parents, they pick them up at school, right? So that's a natural place to pick up the child. So I want to make sure we're not making the judge appoint a sheriff or a sheriff's location in the sense where there's other natural abilities. If it's a mandatory type decision, the judge has to make.
Representative Harris.
That is correct. So the judge will still have the ability to do all of that. This is only in the cases where the judge does not feel as though the parents will be able to properly do the exchange without any issues happening. It would allow both parents to say, hey, I don't feel safe doing the exchange without having a specific place to go. And the judge will then be able to turn around and say, well, here's the location that you all can go to, and they can order that location. Unless both parents do agree that in writing they can make the decision to exchange their child however they have been doing in the past.
Representative McCarron.
So I just want to make sure that it's not mandatory for a judge to designate this. Because the only reason why I say this, I do this, they already do this. They already have the ability to establish a safe place, whether it's the sheriff's department or wherever it is a public place. They already have this authority. So I guess I'm kind of confused on what does this do that is a problem that judges don't already have the authority to do if it's not mandatory. If it's discretionary, they have that discretion now. So I'm just going, what are we adding to this?
So it's not
Representative Harris.
so it's not a mandatory decision that has to be made. But what happens is sometimes there are issues where a parent the court may not think that they've been involved in a situation where the two cannot get along. And so they'll say, okay, well, you all have the child custody order in place and the parenting plan. And so they'll honor that. But then one of the parents feels unsafe in doing the exchange. Well, this makes it to where both of them have to say, yeah, we agree that we can do this safely. We had an incident that took place last year in Austin P area where this similarly happened. This also is a law that actually passed in Florida recently from a case where a situation happened during the exchange where the father got mad with the mother and ended up murdering the mother during the exchange. And so this is just giving them one more tool or opportunity in the courtroom for them to speak up and say, hey, I don't feel safe as the parent of doing this exchange in this way. Judge, can you grant us the natural order of giving us a place to go to? And the judge will then turn around and say, hey, let's do the sheriff's office, and they'll tell them the address and the location.
Representative Garrett.
Thank you, Madam Chairman. And I appreciate the fact that you're trying to bring this, but this is already, if it's not mandatory, the judges and the parties can already do this under our current law. So I feel like this is sort of something redundant, and that and because the sheriff's location, the police location, I mean, already you can do commerce there. If you're doing e-trade, you can show up at the sheriff for a safe place to do that. So I believe we're creating something that's already well redundant, that the judges already have this authority, that if the parties are going to court over custody of their children, they're already not getting along, right? And so we already have that problem. They can already, by motion or whatever the case may be, ask the court for whatever type of exchange during a temporary parenting plan or a temporary exchange of where to exchange the children if that's going to be an issue. So I'm afraid we're just adding something here that Madam Chairman and sponsor is probably not needed. So I'm not going to be able to, I believe, support it at this time, just because I don't know that this is something that we actually need to fix, because judges are already ordering places at the party's requests for a safe drop-off exchange for the children. So that's my concerns on the piece of legislation.
Thank you, and also thank you, committee member, on that as well. This is something that judges have asked for. So obviously there's somewhere down the line where there's a breakdown. So what I'll do is I'll probably have a couple judges come and actually testify, and so we can just roll this bill a week. That'd be perfect.
Representative Powell.
And I'm fine with that, sponsor. I was just going to ask too, in a place like city I represent, Nashville, sometimes a police station might be more appropriate than, say, a sheriff's office. So I was just going to ask if you could also take a look at that in Nashville. You know, the sheriff handles our corrections, but the police would be the actual law enforcement agency. So maybe if you could also take a look at that and some amendment language, because I'd be more supportive. I support it as it is, but that would be helpful in my community.
Great.
You
Thank you.
recognize.
Yes.
So you want to roll 1 week
Yes. Thank you.
with any of the questions? Okay. So we will be rolling House Bill 2503 1 week.
All right, members, that brings us back to the heel of today's calendar, which is item number 1, House Bill 1676 by Chair Lady Littleton.
Thank you, Mr. Chairman.
I've got a motion. I've got a second, and you're probably recognized there, Madam Chair. You also have an amendment 13967. Is that something you'd like to go ahead and put on?
Yes, it does make the bill.
And it makes the bill, members. So we'd like to go ahead and put that amendment on. Looks like we do. Got a motion, got a second. Any objection to adopting the amendment? Seeing none, all those in favor of House Amendment 13967, say aye. Aye. Opposed, say no. Ayes have it. Now we're back on the bill as amended, and Chair Lady, you're properly recognized.
Thank you, Mr. Chairman. HB 1676 is an administrative bill for the Department of Children's Services. This bill, as amended, helps DCS keep children safe by cleaning up several parts of the code related to different grounds for termination of parental rights and other related provisions. This bill would refocus on the definition of severe child abuse to look at the status of the child and the injuries the child suffered, as opposed to focusing on the perpetrator. This bill would also ensure a child would not be placed in a home where a parent or individual cannot be excluded as perpetrator of the severe child abuse. Additionally, the bill expands the definition of severe child abuse by including various human trafficking-related offenses. This change helps the department serve a broader population of human trafficking victims. Lastly, the bill adds a definition for token child support, stating that child support is presumed token if it is less than the minimum established by the Department of Human Services guidelines, and parents and/or guardians may refute this presumption by the preponderance of the evidence standard. With that, I ask for support of this bill.
Very good. Thank you for the explanation. Members, do we have any comments or questions for Chair Lady Littleton? And I will just remind the folks, we do have, I do have some folks on to testify regards to this piece of legislation. So if we don't have any questions or comments now, we can always circle back later. We want to go out of session, hear from our guests. All right, without objection, out of session. And we'll go ahead and Ms. Wrigley, I'm so sorry. If you go ahead and step up, ma'am, and just remind you of the 3 minutes we have of your initial presentation, and of course we can have unlimited time for questions after that. So, and I believe you know the drill. Just be sure that your red light's on, and just introduce yourself to the committee, and you're properly recognized. Thank you.
Of Williamson County for 3 decades. Oh, okay, thank you. For 3 decades, I traveled the state defending parents against over-aggressive child removals. My background includes multiple appeals, 2 historic Tennessee Supreme Court opinions, and carving out civil rights for citizens in the Sixth Circuit Court. This bill will give DCS more power over parents and pushes constitutional limits. It is consistent with my opinion that often criminals have more due process rights than parents. First, it is an unconstitutional reversal of the burden of proof on parents. Second, it seeks to sever parental relationship based on a profound but ambiguous standard of some future psychological event. 1, it reverses the burden of proof in an action against parents, saying that the court must find that a parent can be excluded by clear and convincing evidence before a parent can have access to their child after a finding of severe abuse. To you, severe abuse may sound devastating. However, an accidental injury causing a fractured bone could be taken as severe abuse. This bill means that a parent must prove they are innocent. Ms. Moore is going to speak to you about her case in the Tennessee Supreme Court opinion, which came out in May 2023, in which this bill will reverse what the Supreme Court solidified for parents. that mother has been separated for 9 years. Number 2, the bill allows for a diagnosis of a potential future psychological event, providing that DCS can bring an expert to reasonably expect or predict such a future event. The conclusions are made by experts who are paid by the very agency who wants to terminate parental rights. Tennessee's vulnerable population of parents that do not have resources to hire their own experts and can rarely even hire their own attorney. Sadly, Tennessee has a dearth of constitutional attorneys. The challenge in the courtroom is too arduous and there's no money in it. But you have a constitutional duty as well. Remember that unnecessary parent-child separation is well established as a predeterminant for severe anxiety and long-term psychological abuse for children. This bill should be rejected as written. I thank you.
Very good. And thank you for that. Members, do we have any questions or comments for our guests? Seeing none. Oh, excuse me. Representative Bricken, you're recognized, sir.
Thank you, Mr. Chairman. There's probably a little truth to your statements. Certainly, government granted power seems to overstep their hand too often. And that does scare me. And I think DCS is probably extremely capable of overstepping their bounds. But is there anything in this bill that you can get behind, or is there pieces that could just be modified that you could get comfortable with?
Yes.
Ms. Greeley, you're recognized.
Thank you for asking that. Yes, I think, and 3 times in the bill, it says that the court has to, by clear and convincing evidence, exclude a parent or anybody as a perpetrator. That is a reversal of the burden of proof that needs to be stricken. It's in there 3 times. The second one is this very specific provision that the psychologist can come in and say that we expect there might be some psychological damage. Unfortunately, there is some similar language like that currently, and I've seen the damage where they're trying to predict a psychological event. So unless they specifically articulate the factual basis which would lead, and there's some scientific evidence to show that it's going to result in that psychological event, then it might be able to be supported. But as it's written, it's merely somebody can just come in and give a mental health opinion or a psychological opinion. It needs to have a factual basis. For instance, let's say a child, and I've seen these cases, that they're locked in the closet for weeks, months, whatever. Okay, there are some serious cases where somebody must be able to first articulate the findings of fact before they jump to that next section. The rest of the bill, I don't, I've read through it. I don't really have a lot of major objections. I'm a little bit concerned about the substance or the drug issue, because it says if there are any drugs that are listed in this one section that are just present and available that a child might have access to, that could be severe abuse. And that list is so broad. It includes depressants, it includes ADHD medication, anything that it's a prescription-oriented medication, like an opioid, a stimulant, or a depressant. I think that's just a little bit too broad, because parents wouldn't even know that that's an issue.
Representative Bricken, any follow-up?
No, thank you for the explanation.
Very
Certainly.
good. Members, any additional comments or questions? Excuse me. Representative Powell, I'm sorry.
Thank you. Thank you, Chairman. You referenced the Tennessee Supreme Court case. So would that overturn that actual case, or would that overturn a case similar to it moving forward?
Ms. Gogu?
Okay, so thank you. It would actually reverse what the Tennessee Supreme Court found, because the Tennessee Supreme Court, in Ms. Moore's case, she's going to explain to you, she had a child with complex medical conditions, and it ended up with fractured ribs. They said it was abuse. They took her child 9 years ago. We go all the way up to the Supreme Court, who says This mother had no way of knowing. She didn't expose her child to anything. So the knowing injury or the knowing failure to protect was not present in her case, and they reversed the TPR. Under this law, which I think it will be challenged constitutionally, but who knows when and where, it's actually a reversal of the burden of proof. So the parent would have to come in and prove they're innocent instead of the DCS being required to prove that they had some knowledge or notice of the injury and failed to protect the child.
Representative Powell, any follow-up? Can't see it none. All right, members, any additional questions or comments for our guest? Seeing none, thank you so much.
Thank you.
And next, I want to call Miss Moore. And thank you for being here today, ma'am. If you would just be sure that the red light's on, and then maybe focus your microphone towards your mouth a little bit there, and it's kind of easier for it to pick up. And then 3 minutes for your initial presentation, and then unlimited for comments, questions. Thank you.
Ladies and gentlemen of the committee, my name is Nikisha Moore, and I live in Davidson County. I'm here asking you all to reject HB 1676. In 2015, my 7-month-old baby was taken from me by DCS. My baby had several complex medical conditions when he was born, and I carried him to the doctor multiple times, making sure to attend to his medical needs. In January 2015, I took him to Vanderbilt, where they completed an X-ray and found several fractured ribs. My baby was removed from my care, and I have been in court with DCS for the last 9 years. In May 2023, the Tennessee Supreme Court found that there were no evidence that I have injured my child or that I failed to protect him from injuries. I did not injure my baby. Even the Vanderbilt doctor said that if someone injured the baby, would not have been able to tell because of the injuries would just cause some fussiness. Since the Supreme Court reversed the termination of my parental rights in May of last year, DCS has refused to reunite me with my son. And now they want a law in place that would force a parent like me to prove they were innocent instead of forcing the state to prove that a parent is guilty. Of course, we want to protect our children from harm, but we cannot just reverse the burdens of proof. Please reject this bill.
And thank you for that testimony, ma'am.
Okay.
Members, do you have any questions or comments for Ms. Moore? Thank you. All right, next on our list, I have Mr. Farley, sir.
Real quick, just Mr. Harris, when I worked over in Warren County with the Sheriff's Department, we used the 24-hour jail, since it's always manned, as a place to exchange parents. They do it successfully over there.
Okay.
Might be an option.
All right, Mr. Farley, sir. And you're more than welcome to speak with any member you wish about any subject that was brought in this committee after committee. When you're brought in front of this committee and allowed to testify and speak, you're here to speak on what you're here to speak to with regards to the card that you submitted today. So we thank you for being here. So if you just go ahead and make sure that your red light's on. If you're more comfortable standing there, you're more than welcome to do that as well. Most people sit, but you're more than welcome to stand. Just be sure the red light's on. To speak into the microphone so we can hear you clearly, sir. There's a button, and there's a little mouthpiece beside it there. Ms. Wrigley is going to help you.
It's on.
Okay, sorry.
Okay, good deal. And you have 3 minutes. 3 minutes. Yes.
Sir,
And you're probably recognized. Just introduce yourself, who you're with, and we'll go from there.
my name is Chad Farley. Most committee members know me. If not, I'll be making it around. I had a speech prepared today, but hearing all this information about language, we're worried about being sued. We're worried about having judges speak to each other and communicate. That's the problem. 1676, if passed, gives the language for DCS, these people, to cover anything. You won't have to worry about lawsuits because qualified immunity. They don't want you to see the transcripts within the judicial system showing that caseworkers lied, police lied on the stand, but judges don't hold them accountable. Constantly, caseworkers, actual text messages, audios. See, they just want to keep pushing a narrative that is so pornographically wrong on my case, but it's not my case. Is Mr. This gentleman over here? I talked to him this morning, and I appreciate that. But sir, if you can't recognize what DCS doesn't want you to see, 4,000 minutes of therapy notes, my child, the center of this, who is in real bad shape. There they are. They don't want you to see those. It's this, the GAL, the VA, who forced me, an American veteran, to plead to a charge so they could keep my child. It's on tape. You guys don't want to listen. All I'm asking is to please sit down with us and let us work with these people. We're locked out of the executive level, and that's the problem. You know why? I went to the governor, and I gave him an internal complaint. I gave his aide hand to hand. The next day, he assigned an internal review. I went to DCS, and I met with them. They removed the caseworker. Surely by now, they have talked to everybody all the way down to Omni. And I guarantee you, the executive team knows exactly, in my case, what happened. And just as he said, stop focusing on my case. That's what this gentleman over here told me today. Stop focusing on my case. That's fine. Let's focus on the language, because it's the language in these bills that the children and families really need protection from, because there's no specificality to this. Like my case, they roll everybody that was in the house. There was other adults there. They roll them out, and what they're going to say is, we couldn't determine if they were involved or not. That's what they're going to say. They've done it. It's in my case. Please, Representative Johnson is up here talking about, what if you were sitting in a child was sitting in a room, a deaf child was sitting in a room and couldn't understand. Well, let me tell you, I know.
Thank you for that,
because
sir.
I sat
That's
in
your
court in East
three.
Tennessee.
That's your 3
I
minutes.
couldn't even see through people's
and
masks. I
you
read
hit your-
lips. I have cochlear implant. Oh,
Okay.
shoot, sorry.
No, you're fine, and we appreciate your testimony, and it's clear you've. We'll give you a moment to pack your things.
Thank you, committee.
Sir? Sir? Oh, yeah.
So sorry. So sorry.
Yeah, not only do you have 3 minutes, but we allow for unlimited times for questions and comments from the committee.
Please ask me questions, please.
Sure. Yeah, and that's what we're here for. Members, do we have any questions or comments for our guest? Representative Gant, you recognize, sir.
Mr. Chair, I just want to thank the gentleman for his service to our country. As he mentioned, he was a veteran, so I just wanted to put that on record.
Thank you, sir.
Thank you, Representative Gant. Members, any additional questions
Sir,
or
am I
comments
able
for
to
our guest?
respond to that?
No, you're not.
Okay.
Just let me make sure we got any more questions. Actually, you know what? Go ahead. Go ahead.
I was just going to say thank you. I appreciate that for seeing that. But it was a narrative that stripped everything. I saved nuclear bombers right after 9/11 started. I did it because I wanted to, but the narrative that DCS set on my family was so wrong. And it stripped everything from this, and it means nothing because nobody even wants to pay attention because it's already been said. Oh my God, stay away. Thank you for saying that, though.
Thank you for that response, sir. And members, any other additional comments or questions for our guests? Members? Okay. And thank you for being here.
Thank you for your time.
Thank you. And that brings us to Miss Jessica Farley, ma'am. And you're welcome, just as I believe your husband, you can either sit or stand, and just be sure the red light's on. You got 3 minutes. for your initial presentation and unlimited time for questions and comments afterwards. And thank you for being here. Just introduce yourself and let us know who you're with. Thank you.
Thank you. I'm Jessica Farley. I'm here by myself. My husband's with me, but I have a different topic to talk about than he does. Thank you.
Yeah, kind of get that microphone close there,
Sorry.
and we can hear you much better. Thank you.
Okay. What I wanted to talk about was the medications in the bill, because there's 11 pages of medications and it's a very broad. I had to Google most of them. I couldn't, they weren't typical names, and just the ADHD medication and the depressants, we don't get notified when we're at the doctors or pharmacists to keep them in a locked box. But when DCS does a home visit, like they did with my mother, they inform her that they need to be in a locked box. I can't tell you countless times my son being 11, 12, I would find his ADHD medication that I thought he was taking all over the house. And that to me does not constitute a severe abuse. That's my testimony.
Okay. And thank you for that. Members, any questions or comments for our guests? Seeing none. Thank you for being here. Next on our list, we have the Department of Children's Services. I have Doug Diamond, Emmett Owsley, Hayes O'Donnell, Jim Lehman, and Sammy Mayfair. And I don't know if you all, everyone doesn't have to come up here, obviously, but whoever wishes may. Okay. All right, and appreciate it. And I know you all have been here before. If you would just go ahead and introduce yourselves to the committee, let us know who you're with, and you will have 3 minutes collectively between the two of you to state your position, any response that you may have, and then we'll have unlimited time for questions. So whenever you're ready.
Thank you, Chairman and committee members. My name is Jim Lehman. I'm the Legislative Director for the Department of Children's Services.
I'm Sammy Mayfair. I'm Deputy General Counsel for the Department of Children's Services.
And thank you. I know we had a chance to speak with most of you, I think, before the committee about some of the reasons for this bill, some great things that we are in support of. Obviously, it's a department's administration bill. Things like expanding the definition of severe child abuse so that we can serve more human trafficking victims under that category. Expanding or changing the definition of token child support so that we can help us prove the grounds of failure to support by helping define what token child support is. I think the biggest, I guess, sort of testimony that we've heard is about some of the changes being made to severe child abuse and abuse. And I get out of my wheelhouse with that. So I'll probably let Sammy testify about that, if that's all right.
Sure. Yes, and so as far as the actual definition of severe child abuse, we're not making any substantive changes to them other than adding those specific trafficking offenses that Mr. Lehman mentioned. Excuse me. The existing categories of severe child abuse that are in the law are the exact same. We're just rephrasing them to make it clear that when the court is making that finding, it is about the status of that child, that child is a severely abused child if these conditions are met. And then separately, once that court has made the determination that they are in fact a severely abused child, the court has to make a secondary determination of who caused this. That's when we look at, is the parent a perpetrator, is the caretaker a perpetrator? Who knowingly or with gross negligence subjected this child to severe child abuse? And in circumstances where the perpetrator cannot be determined, the court is to look to see if the parent can be excluded as the perpetrator. So we don't have circumstances where you have two parents, for example, you have a baby that is severely injured. Those parents are the only ones who have been responsible for the care of that child. Neither parent is saying who harmed the baby, but we have a harmed baby. And so we want to have a circumstance where we are not compelled to put that child back into that same home where we know that child sustained a non-accidental injury without a court having an additional level of oversight to make sure that it is in fact safe to return that child to that type of home.
And with that, committee, we stand happy to answer any questions if you.
Very good. Members, any questions? Representative Powell?
Sure. So we heard some testimony about Tennessee's Supreme Court case and how this would overturn that. Can you speak to that? Because I'm trying to make sense out of that.
Sammy Mayfair, DCS.
Yeah, you're recognized.
Thank you. So it wouldn't overturn what had happened in the Enright Marquesi case. That case is established. It would move forward. In cases subsequent to the passing of the law, then what it would do is require the court to have that additional level of looking behind what happened in these cases of severe child abuse. We wouldn't have a chance to re-adjudicate what happened in that case. That case is established. So it wouldn't overturn it. It would redefine how courts are looking at these severe child abuse cases.
Representative Powell, you're recognized.
And I haven't read over the case, but it was the case overturned because of the way the case was looked at, or was the case overturned because there were, I guess, was it more technical in nature, or were there actual findings that they went back and looked at that were to that specifically on that circumstance?
Ms. Mayfair?
So the way that we have looked at and interpreted that case is, the court made certain findings that it was clear that that child had been failed, that the parents had failed to protect that child from injury. The Supreme Court said that in its opinion. The issue was around proving the knowing failure to protect as to both parents, so that they failed to protect, but the way that the statute was written, it did not qualify as severe child abuse because when we tried our case, there was not enough evidence that both parents had knowingly failed to protect. So it didn't meet the threshold of the definition at the time.
Representative Powell, any follow-up?
One last question here. We heard testimony this would take away the burden of proof, basically that that issue was raised, and almost like would flip that process. Can you speak to that? Do you feel like that's, because I haven't heard that from what you're saying on this bill?
Ms. Mayfair?
So I believe that the burden shifting happens after the court has made a finding that the parent cannot be excluded as a perpetrator. That burden shifting already exists in the law in circumstances where parents have been found to be a perpetrator. So currently, if I am found to be a perpetrator of severe child abuse, the court then must make a finding by clear and convincing evidence that I'm not going to subject a child to further abuse or neglect before that child can be returned to my home. That stays intact, untouched. What this does is it adds that secondary category where in the proving of the severe child abuse case, we prove that the child is a victim of severe child abuse. We cannot prove that either parent knowingly committed the act or knowingly failed to protect the act, but the parent cannot be excluded as a perpetrator. The court reviews the case, the proof that we have put on, and makes a finding that the parent cannot be excluded as a perpetrator. Then there would be a burden shift, similarly to if they had been found to be a perpetrator, that the court would have to make certain findings before the child could be returned to their home.
Representative Powell, any follow-up? Representative Bricken, you're recognized.
Thank you, Mr. Chairman. Maybe I have two questions. First, y'all brought this bill to the administration. Is that correct?
Ms. Mayfair?
Yes, sir.
Or
Yes.
Mr. Lehman?
Is it based on so many, and maybe I'm asking the question is, are they, over the last year, 2 years, can you identify the number of cases that you think would have fallen under this legislation had it been in place, that we have returned kids to parents that we shouldn't have, or if that's a reasonable question?
Ms. Mayfair?
And yes, Representative, I think it's a reasonable question. I don't think that we have data that we can pull to say specifically that this many cases, that circumstance happened.
But is this a reality, or is this, I must say, and I'm not struggling with my question here. Do we know we have a problem that this legislation is going to fix, or do you just try to get it in place so y'all can have another tool in your tool belt to use?
Mr. Lehman?
Chairman, I think it is something that, our attorneys have felt that it's come up enough that it warranted addressing in legislation. Apologize for not having, a specific number of cases. I do think, from what I understand, it comes up more often in cases where there are younger children and the children are unable to testify about what mother and father did, or, the guardian did. So I can ask our folks, it is a fairly limited fact circumstance that this addresses, but I'll do my best to find, some numbers for you.
Thank you. I guess the other piece that I'm having trouble with is the added definition of, I guess it goes under child abuse, dealing with the involuntary labor, servitude, trafficking for forced labor, patronizing. I can understand if it's child prostitution but I guess I'm trying to get examples of that y'all have experienced in trafficking for forced labor services and things like that would come under the definition of child abuse.
Ms. Mayfair?
I mean, I'm not going to even be lied about forcing my kids to rake yards, but keep going.
No, sir, this is aimed specifically at circumstances where we have children that are in our custody that have been trafficked, either for, again, labor, servitude, sex trafficking. The ability to adjudicate severe abuse against those individuals who were caretakers. And, if a parent had put a child into that met the statutory criteria of trafficking, that would also constitute an act of severe child abuse.
Can you give me, Mr. Chairman, excuse me, if I could stay with it, some examples, especially of the forced labor trafficking?
And so those are around the situations where a parent sells a child or puts a child into a situation where they are working against their will, have been transported to be working against their will. And it's not just, to your example, sir, of, well, I made my kid get a job down at Sonic so that they have job experience. It's the actual criminal act associated with trafficking that child for that purpose.
I guess so. No other question.
Representative Garrett, you're up.
Thank you, Madam Chair. But Representative Powell's, I had a question regarding the burden that would sparked my interest, but I believe you addressed it. In line with the burden of proof, the shifting or the extra layer, can you provide some sort of an example of that? Because that does seem problematic in a lot of ways, to further increase a parent's ability to be at the table, right? So if regardless, I mean, we're talking about severe child abuse, right? So there's some real allegations here. The state they have a great interest in protecting that child. So I'm not suggesting that they don't. But if you could just give an example, something happened that if you can be, I know you can't any specific case, but this has had to happen where this is necessary. Can you provide us some color on what that was, where that increased or different stage of a burden for a parent in this particular circumstance warrants the reason why this legislation has been brought? That would be helpful for me.
All right, either Ms. Mayfair, excuse me, I apologize about that, or Mr. Lehman.
So under the current law, like as severe abuse exists currently, say for example, we have a mother that has been adjudicated as a perpetrator of severe abuse because she has exposed her child to in utero substance use. She used methamphetamine throughout her pregnancy. Child was born, tested positive for methamphetamine. Court makes the finding you are a perpetrator of severe child abuse because of that. For her to regain custody or for a return of the child at home, she does have to demonstrate the court a change in circumstances. And so that's what that is aimed at. And so in those circumstances, she shows that I've completed alcohol and drug treatment. I have maintained my sobriety for a period of X amount of time. I have obtained a house. I have obtained these things. So similarly to what we would have to show in any other circumstance where they were gaining custody, it's just that because there has been that severe abuse finding, the court has to look at that a little more closely and say, okay, not only have you done these things, I find by clear and convincing evidence, because of these changes you've made, you're not going to subject that child to further abuse or neglect. So that's the law as it currently exists with severe child abuse. What this would do is then add that separate prong in those circumstances where the court has found I couldn't exclude you as a perpetrator to having to do those same things. So if you have the scenario that we've talked about of, you have a young, vulnerable, nonverbal child that has sustained a non-accidental injury, a broken bone, whatever that might be, and the court finds I can't exclude either of these parents as perpetrators, they would have to demonstrate, I have undergone counseling, I've done parenting. These are the things that I have done to show to the court that my home is a safe home for this severely abused baby to return to.
Representative Garrett, you're recognized.
Thank you, Mr. Chairman. Thank you for that clarity. That provides me a step process. So if the judge declares that they can't exclude them as a potential perpetrator, which means suspect, for lack of a better word, that they were causing this particular injury, the parent, though, at the time, does the parent know at that time that they're not excluded under this legislation? So they can have the rights to stand up and say, wait a minute, I should be excluded, whether or not it's to get an attorney or whatever the case may be in the process. So their rights aren't. Okay, you're nodding. So yeah.
If we get that the answer to that, that'd be great.
Yes. So this would be in the context of an adjudicatory hearing. So this isn't just a finding that the department has made or anything like that. This is when we have tried a case, a court has already found the child to at least be dependent and neglected. So we've met a clear and convincing evidence that a child is dependent and neglected. Then the court must also make a finding as to whether or not that child is a victim of severe abuse. If yes, the court must also then make a finding who is the perpetrator, or can we not exclude you as a perpetrator? Okay. And that is all done in court, in a hearing. Parents may have appointed counsel, hired counsel, but it's all done in that context of that adjudicatory hearing.
Thank you very much for that clarification. I really appreciate it.
Members, any additional questions or comments? Chair Lady Littleton, you recognize, ma'am.
Thank you, Mr. Chairman. And we do read and we do see that if a child is born exposed to drug in the womb, if they're exposed to the drugs, a lot of, I guess 50% of the time, maybe 60, the parents go back on the drugs and the child is at home with them. So the child is usually, that's where the child abuse usually comes from. Would you agree with that? Maybe not my numbers, but almost every time.
Shirley, I don't think I have specific percentages that I can say, but we do have cases where a parent has sustained a relapse after a child has been placed back into the home, yes.
And would you say that's repeatedly several times on some cases, many cases?
There are cases where that has happened on multiple instances, yes.
Thank you, Mr. Chairman.
Thank you. Members, any additional comments or questions for our guests? And I do have just a follow-up to Representative Garrett's line of questioning. So, for example, and you gave the example, Ms. Mayfair, to where there was a mother that had been using drugs and the child was born, and that's easy to follow, right? We know where that came from. But then you have the situation where there's two parents or maybe two parents and a grandmother or somebody that lives all in the same household, which is fairly common. We have a child that's hurt, and we have charges that are brought. Charges that are brought against maybe all three. So let's just with the example of the mother, father, grandmother, grandfather, whatever. We have charges brought against all three. And then there's a finding of severe abuse charges brought against all three. And there's a finding, adjudication, order goes down against one. And then this second separate hearing, is it a substantiation hearing with regards to all three, or is it just to the one? I mean, how does that work in that situation? Because that's a little more complex than the mother that was using drugs and had a child.
Right.
So I guess if we could give that example to folks, we may have a better understanding.
Sure. So in that example, that we have mom, we have dad, and we have grandma all living in the same house. We have a baby with a broken arm. Nobody's saying who did it, but they were in the exclusive care and control of these three individuals at all times. Then in that circumstance, the court would make the finding of that child as a severely abused child, and then go to that second tier of who either knowingly or with gross negligence committed the act, knowingly or with gross negligence failed to protect.
May I pause you right there? You said the court then makes a finding of severe abuse. Are you saying that there's a trial and they had a hearing and the court those all three have been adjudicated to have committed severe abuse against that child? When you say finding, what's that mean?
That is as to the status of the child. The court finds that that child is a victim of severe child abuse. Then it enters a separate phase where it talks about, okay, we know this child is a victim of severe child abuse. Under the law, certain broken bones, that's a serious bodily injury. That is severe abuse. Then we look at, okay, so who caused this? So it's, did these three people, do we know who did it? Did they knowingly or with gross negligence cause the severe abuse? If the court can determine, okay, dad admitted that he was the one that broke the child's arm, everyone else panicked and we took the child to the hospital and everyone acted appropriately, then we're going to find that dad is a perpetrator of severe child abuse. No findings against anyone else. Maybe the circumstance is dad broke the child's arm, told mom, everybody hit it, grandma had no idea. Maybe grandma was on vacation. In that circumstance, the court would look at that and say, okay, we know dad broke the arm. We know mom knew about it, didn't take appropriate actions. She's failed to protect. So we find severe abuses to both of them, nothing with grandma. She wasn't involved. If we have a circumstance where broken arm, nobody's talking, all three of them were in the room, healthy baby goes in, broken baby comes out, then at that point, the court would look at all three of them to determine, can they be excluded as a perpetrator of severe abuse?
And to follow up on that, and that's for the purposes of whether or not can return home.
Return.
Okay. And if there are findings of, if you are found to be a perpetrator or substantiated as a perpetrator of severe abuse, is there a pathway back, as you were talking about classes, rehab, things like that? Is there a pathway back to that child?
Yes, we do reunify parents that have an actual finding of that they are a perpetrator of severe abuse.
Okay. Okay. That's all I have. Representative Harris, you recognize.
Thank you, Chairman. And so if, for example, if grandmother goes on vacation and there's a mom and dad are there, and again, goes back to if neither party says or admits to the situation, how do you all relinquish, say, grandmother from being a perpetrator in those cases? How would you determine that? Or what if she just, if her son-in-law, she just throws his name out there and says it was him? Do we take her word for it, or how does that work for in those cases?
Ms. Mayfair?
I mean, so that would be part of the investigation like we do in any other child protective investigation case. So we would try to gather as much information as we have to help determine who is the perpetrator. And then we would present that information to the court, who would be the ultimate trier of fact to determine, yes, this meets this criteria, or no, it does not.
Representative Harris, any follow-up?
But if all three of the individuals are unable to be determined in that case, do you all find fault in all three, or do you just dismiss that in those matters, kind of like the case that happened?
So under this bill, this would then require the court to look at all three of them to determine whether or not they could be excluded as a perpetrator and make that finding. It wouldn't be a finding that the department would be making.
Any follow-up? Members, any additional questions for our guests? All right, thank you. All right, and that brings us to the end of our list of folks that have given notice to testify. So without objection, we'll go back into session. Chair Lady Littleton, you recognized?
I just ask you to vote for House Bill 1676.
All right, members, any additional questions or comments for Chair Lady Littleton? Are we ready to vote? Any objection? Seeing none, looks like we're voting whether or not to send House Bill 1676 as amended to Civil Justice Full Committee. All in favor say aye. Aye. Opposed say no. Ayes have it. Bill moves on. And that brings us to the conclusion of today's calendar. I'd entertain a motion to adjourn. All right. Thank you. We're adjourned.